I spent a couple of days going through Friday's testimony when we heard from the cell phone expert and Trooper Paul on accident reconstruction. After I spent a couple of hours recording, I ditched all of it. I realized I had fallen into a trap, and I think it's possible others may have as well. I'll get to that. I do want to make some remarks and ask some questions first before I make my major point at the end. The phone expert, Jessica Hyde. Lally did the usual ask for her qualifications. She seemed to want to ensure that everybody knew she was former military, even though that had nothing to do with her qualifications. She kept repeating active duty, and at another point said she went to complete her tour. I wondered if that was about her or if someone told her to stress that because of the influence that can have, especially considering how Lally had used the funeral of the fallen New York police officer. I went back and listened to it again and noted the first time she used that specific term, active duty, was when she was asked about her schooling. She used it to explain why she went to several different schools. She inserted her military background 5 times within the first few minutes. And within her testimony, she also inserted things like, I missed doing public service. My instinct is to dig into that, kind of like when Watson picks up a scent and goes after it, but I didn't. Trooper Tully contacted Hyde May 4th, 2023. That time frame jumped out at me. Jen McCabe's Google searches became public in April 2023. And it was only after that when Jen changed her story to claim that Reed repeated, I hit him. Tully asked Hyde to look at Jen's Google search, how long to die in coal. Since Hyde's company is private, there has to be a contract. When authorities enter into these contracts, they have to set out the scope of the work. Part of the reason for this is cost control. Another reason is that the expert needs to understand what it is the client is looking for. If the scope is too broad, you waste resources. If it's too narrow, you miss information that might be important. I noted she was asked to look at the tab for that particular search and to put that on a timeline. I wondered why she wasn't asked to look at everything in that time frame rather than one tab and 2 search terms. She talked about fragments marked recovered and said that can be misunderstood as meaning deleted. And this happens to be the subject of a paper she co-authored. Based on what she's saying here, everyone convicted in cases that involved deleted data is going to want their cases looked at, and every current defendant whose case involves deletions now has something to go after. She says the information shows that the search term was on a suspended state tab. Let me ask you this. If this was the defendant's phone, and she was saying that the Google search, which appears to have been made around the same time as Brian Higgins and Brian Albert were butt dialing each other, if the defendant was saying this was really just a misunderstanding and all due to leaving a tab open, and the deletions aren't really deletions, what would you think? But it's not the defendant's phone. It's the phone of a suspected accomplice. What would you say if Corey Richins used this defense? Having said that, of course, if the knowledge of experts has evolved, then in every case in which this new understanding would have made a difference, they're going to have to look at it. If this is groundbreaking knowledge, then it should be put out there, and every defense attorney and every prosecutor has to be given the information. Another question. Did Karen Reed delete Google searches from her phone during this time period? Did Reed tell the police she wanted to delete some text messages before handing over her phone? And this whole thing could be shortened and or clarified if we could see the video from inside Good's cruiser. McCabe claims the search was made while she and Reed were sitting in the back of that cruiser, and that Reed insisted McCabe do that search. There should be footage of that interaction between Reed and McCabe. Why is there no video of that being presented? It could have been presented at the time of McCabe's testimony. At one point in her testimony, Hyde said the browser gave a suggestion of how long to digest food. Now, why would the browser suggest that instead of something related to an earlier search, like how long to die in the cold? Or, considering McCabe had been looking up sports-related, basketball-related things, why would how long not prompt the suggestion of how long does a basketball game last? Or how long to drive to this gym? And I have a question about the open tab too. If Jen went to sleep without closing the app, I know people leave apps open. Was she in that habit? And if Jen did not close the tab when she was comfortably home, how is it that she thinks to close it in the morning when, as she says, her hands were trembling and Reed was grabbing her arm? If you go to use your phone and an app is sitting open there, don't you quickly tap to close the app? Jen was on her phone a lot that morning. Why is it that no one believes in a single coincidence when it comes to the accused, but they'll believe in multiple people having multiple coincidences which occur coincidentally in connection with each other? It's so bad that the prosecution has to call an expert witness not to prove the defendant's guilt, but to attempt to prove someone else's possible innocence. I didn't hear this witness definitively assert that this search could not have happened in the middle of the night. And why does Jen McCabe have to make the same search twice at 6:23 and 6:24 in the morning? And did I mention the video from Good's Cruiser would be very helpful here? Yeah, I know I mentioned it. I'm mentioning it again. The witness said McCabe's phone was in use at 2:27 a.m. So if she was not searching how long to die in the cold, and she didn't search anything about basketball until 2:47 a.m., so 20 minutes later, what was the search at 2:27? And we know that tab was open at 2:27 a.m. If the phone was in use for some reason other than to be searching for anything, well, then that tab doesn't get opened at 2:27. And if that tab doesn't get opened at 2:27 and it gets opened at 2:47, then why doesn't the last search on the tab at 6:24 in the morning, why does that not move to 2:47 instead of 2:27? If what the expert is saying is right, it's off by 20 minutes. The cross-examination was short. The witness said the timestamp is related to the tab, not the search. In the end, she couldn't definitively say that search was not done at 2:27 a.m. But she did say she didn't think so. I didn't get into the nitty-gritty of all the tech stuff in my remarks here. And part of that is because I knew I would bungle it. When it comes to tech, I'm pretty useless. And this is where you can help me understand. There are questions within all of her testimony that I wouldn't even know to ask. So tell me, what questions need to be asked about what she covered in her testimony? In particular, I want to know what was omitted. What questions did Lally not ask? What was not looked at? What details or context did Lally gloss over? We know that's a pattern of his. All you techies out there, Talk to me and the rest of us so we understand. Moving on to the accident reconstruction. I'm going to talk about Trooper Paul's testimony, and then I'll tell you why I deleted 2 hours of recording. He said he went to Fairview with Lieutenant Gallagher, and the purpose of this was to show Trooper Paul where the evidence had been, but Gallagher wasn't there at the scene. At the same time, O'Keefe was there. So I don't know how he could accurately point to where O'Keefe was. None of this would be an issue if when Proctor got the call, he did what he was supposed to do and told Canton Police to either hold the scene, secure it, protect it, and wait, or if he had given instructions such as, hey, you need to take measurements. So now they're guessing. As he was talking about the tools that he uses to make his measurements, and that includes a drone, and how those tools work, he said they utilize GPS, and then he said, as well as cell phone towers. So I go back to my question from before in respect to Reed's phone and why they used cell towers instead of satellite GPS, which would have been much more accurate. Now, somebody in the comments pointed out to me that the Commonwealth would be in a bad position if they said they used GPS data from Reed's phone, because the Commonwealth had also said that the GPS for the town had been down. So I'm wondering if there's going to be information as to when it went down, when did it come back up. I'm just a little bothered about why we didn't hear why they didn't use GPS for Reed for her phone. And there may be a perfectly innocent, reasonable explanation for that. I just want to know what it is. He said he plotted roadway evidence onto the map. And what he means by roadway evidence is anything that is really related to the crash, debris, that sort of thing. And as I listen to this witness, I'm thinking the process he used, the tools he used, all seem fine. The witness himself seems fine. No big red flags here, except there's one thing. The scene wasn't secure. It wasn't measured and plotted out in the beginning. And so any locations that Trooper Paul is given for this is where the victim was, this is where this piece of plastic was, etc., is going to be based on either what somebody told somebody and is now being told to him instead of an actual measurement, or based on a guess and or based on a tool that was used earlier that has an error rate of 16 feet. And in this kind of scene, in this reconstruction, 16 feet can be a big difference. Your analysis is only as good as the information that goes into it. Bad information in will lead to bad information out, no matter how well this man does his job. I'm looking at this map he's got. So this is February 1st. He says he's doing this. Before Trooper Proctor went there a bunch of times and found a whole bunch of other stuff in the days and weeks following this. This witness is doing this reconstruction initially based on the shoe, where they think the victim was, the glass cup, and 3 pieces of plastic. And by the way, somebody pointed out to me that on a Lexus, the material is not actually plastic, but that's a whole other conversation. And remember the bags that the evidence bags that the defense had Tully open, and there were extra pieces of plastic in those bags? And Jackson had challenged Tully, saying, wait a minute, your report said 3 pieces of plastic. Where did these other pieces of plastic come from that are sitting in these evidence bags? And Tully said, I'm going to have to take the hit and say my report is wrong. And the evidence bags are correct. Well, on this map, there are only 3 pieces of plastic represented here. So where are the other 2? Because all of the reports can't be wrong. And Tully didn't write his report until February 10th. So Trooper Paul can't be relying on Tully's report, right? So here, there are 2 pieces of plastic supposedly found on the 29th, not accounted for here. And the whole thing with the dates on the evidence bags is still outstanding. That question has not been answered. This thing with the plastic is bothering me. I have a question about how, whatever conclusion this witness comes to, how would that change if he learned that the locations of all the other additional pieces of plastic and the fact that there were so many pieces of plastic. There was one found right in front of the fire hydrant, right? So I wonder if his conclusions would change. Lally asked him, did you put every single piece of taillight that was found on the 29th in this diagram? And the answer was no, I did not. Why? What the heck? Lally doesn't ask, why not? Give the witness to explain his reasoning. He just moved on. Lally asked about the condition of the asphalt in the Canton Police parking lot where this witness was testing the vehicle, and he said it was wet. And Lally tried to make the comparison to the roadway at Fairview at the time that they're saying that her vehicle would have been involved in the incident. And the witness said, well, it had just started to snow, and so the road would be wet. For those of you who have driven in snow, you know what that's like to drive. You know, that snowfall that is just falling. It's wet. It's a little bit slushy, right? It's a little bit slushy, and that is actually more slippery than simply wet. Now, I don't think that's actually going to matter in this case. Lally can't have it both ways. If he wants to say the condition of the roadway at Fairview on the 29th was that it was wet, not even slushy, then how does he explain how John O'Keefe ended up on top of a whole lot of snow? Oh, right. We're supposed to ignore the photographs and the video we all saw of where John was laying. We're supposed to forget all about that and go with the narrative. They introduced into evidence the data retrieved from the airbag control module. From this data, there were no events recovered. And Lally, before he elicited this information, made sure that he got the witness to say that the data in this is designed to protect the occupants of the vehicle and not pedestrians or anything outside the vehicle. And the witness did testify that finding no data or no events from where they extracted this is not unusual. He said it's not uncommon for pedestrians to lose items of clothing such as shoes. He even said belts, hats. He's saying anything that's not strapped on very well could leave the body. He says that other items, and Lally is really referring to the glass, right? So other items will also go in the direction that the pedestrian is going when they're hit. And you could see that, right? If you have a drinking glass in your hand and you're struck, you have your purse in your hand, right? Whatever it is, and you're struck, if you're hanging onto that thing, it's going to go in the general direction that you are. How does the drinking glass end up either under or right beside John? It's going to fly out of his hand. The weight of the drinking glass and the weight of the man are different, as are the physical properties, the shape of it. And he's saying to determine the point of impact, they follow the debris back. And so where that first piece of debris is along that path is the point of impact. But in this case, later on, they found additional red plastic right at the fire hydrant. So would that not change the calculation here? He talked about Toyota Tech Stream software. and it can show a vehicle control history. And he says there are certain triggers, and when those triggers are met, then it starts to record. He testified that the camera systems in some vehicles can record photos, but he was not able to recover any photos from Reed's vehicle. The extraction of the Toyota TechStream data was done on February 2nd. And the reason he didn't extract this data is because at the time of this case, he didn't really know much about it and he was just learning about it. And it was on February 2nd that he realized, oh, hey, this might be relevant to our case. They talked about key cycles, and the times are estimated and based on other things. So it's not clear as to what times different speeds and different events in the vehicle occurred. Lally asked about the infotainment system, and Trooper Paul said he wasn't involved in that. Yet Lally tried to get this witness to testify to what another witness would say. Lally introduces photos and shows there's an infotainment system there. And what he's after, what he's been trying to get out for a while now, is that there's a backup camera. Let me just say that while backup cameras can prevent collisions, they don't prevent all of them. In order for it to be useful, the driver has to actually look at it. And I know there are beeping sounds like a warning system, but if you're driving fast, not paying attention, you're just in a rush, you might not listen to that. Especially if you're backing out in a spot where you routinely back out and that little beeping alarm goes off every time because it's a tight spot, you might ignore the beeping. On the morning of the 29th, Reed's state of mind was such that I'd be surprised if she was paying attention to this backup camera. And we still don't know what was wrong with the garage door. Lally and this witness went through a lot in order to demonstrate that it is, and I quote the words, within the realm of possibility. They wanted to demonstrate it's within the realm of possibility that Reed's Lexus hit John O'Keefe. And here is where I get to the trap I fell into and why I discarded so much of my work. And it brings us to a major point. The trap. I focused on every little detail, following the path set out so I could make sure I correctly understood the points the prosecution was trying to make. That part is okay, but it becomes a problem, a trap, when you don't put all that in a broader context. When you go off into the weeds, at some point you have to poke your head up and look around. It's like how people keep debating whether the injuries on John's arms are bites or scratches. They get so focused on that debate that they miss the point that they're not from a Lexus. Bites, scratches, tomato. It's not a Lexus. With the accident reconstruction, I did exactly this. Measurements, physics, times, speeds. But that package of details is sitting in a vacuum. Even if all of the measurements could be perfect, if you ignore the absence of the rest of the plastic that would change those calculations, if you ignore some of the physics issues, like how a round glass doesn't roll any distance given the force, velocity, and directionality of its travel, if you ignore that the taillight on a Lexus is made of material that doesn't shatter, never mind explode. Let's pretend the question of whether or not Reed's vehicle could have hit John O'Keefe, whether that was within the realm of possibility, was 100% proven. The standard of proof is not could have, not whether it's within the realm of possibility. The standard of proof is beyond a reasonable doubt. So let's pretend for a minute that this reconstruction is perfect. Let's pretend Jen McCabe didn't make that Google search. Pretend Reed did say I hit him. Pretend Lally hasn't twisted or omitted anything. Pretend the Commonwealth's case isn't as full of holes as a fisherman's net. Pretend all that and then put it in context with the physical evidence. You know, the thing that isn't lying, the thing that all of you can see with your own two eyes, the snow under John, the snow the glass was wedged into, the snow the blood was on top of, all that snow that had not yet fallen by the time they claimed John O'Keefe was down on the snow in front of 34 Fairview. Is it within the realm of possibility that Reed's SUV could have hit John O'Keefe? If you ask that question in a vacuum, then sure, you could make that argument. Could this have occurred at or around 12:30? No. The only way that works is if John's body, the drinking glass, and the blood all remain suspended in the air for hours to wait for the snow to fall, so that they could all land on top of the snow. That's all I've got for you for now. Trust your gut. I'll see you in the comments.